Okay, welcome everybody tonight to our June 3rd meeting. Hopefully this will be our last virtual meeting. I'm hoping that this is it. So before we get started, we stand up and have the pledge. There's a flag over here if you have a flag where you are. So here we go. I pledge allegiance to the
To the
flag
flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, thank you. Before we get started, let's see if we can kind of say who's with us tonight, just so we know. We have the town board with us. We have Steve Moreau, Andrew Riegenbaum, Steve Bedetti, Sylvia Santiago. And we also have our town attorney, Dave Zagon. Franny Roth is going to transcribe this. We also have the town clerk here with us today, Kelly Allegra. Patrick Mangan, our IT department, is handling this virtual meeting, and the supervisor secretary, Patrina Rapper, is here and should be handling emails that come in from anybody. So the first item on the agenda is the public hearing, Diversified Properties, their request for administrative relief from Local Law 1/2020, the temporary moratorium. So to get us started, I'd ask Dave Zagon, the town attorney, want to get us started?
John, can we unmute John? And perhaps Nick as well? All right, John, you can hear me? Nick, you can hear me?
Yeah, I can hear you.
Yes.
Okay. So with regard to Diversified's application for administrative relief, the board has received it. They've been, or I received it. I provided the board with a copy. I provided the board with a copy of all the affidavits that you submitted on Diversified's behalf, John. Any other information that you provided along with the application. We have also received a number of emails and correspondence from residents, which have been provided to the town as well. Everybody went blank on me. John, you can still hear me? Nick?
Yes, I can hear you. I just see a DZ up there. There you go.
Okay. So before I give Diversified, whether it's John, Nick, or both, an opportunity to make a further presentation, again, please take note of the fact that the board has received your application, which was quite extensive. There are, however, what I perceive to be a number of omissions from the application, just in terms of the facts. So I would like to ask some questions of you to try and fill in those blanks for the board. When I'm done with my questions, I will give one or both of you an opportunity to speak and make a further presentation to the board. I'd like you to keep your remarks combined. I don't know, again, whether or not Nick is going to be making any statements to the board. I know, John, I believe you are. You told me that. You didn't know that Nick was going to. But combined, if you can keep your comments as best you can to around 10 minutes, which is, 3 times the amount that we normally would allot for an applicant or anyone who wants to speak on behalf of or in opposition to whatever application is filed to speak. When you make your presentation, I would also, because I just got the sense from our conversations beforehand and some of the correspondence that went back and forth between us, that you may be looking to make a pitch, so to speak, to the board, above and beyond really the issues that are relevant to the hearing. And if I'm wrong, that's fine. But I just wanted to tell you that beforehand and ask that you try and stick to really the 3 criteria that need to be made out by Diversified in order to have the board grant the application for administrative relief. The first, I'm just going to spell those out for you to the extent that you're unaware. I doubt that you are. But the first would be why, including dollars and cents proof that Diversified can't make any reasonable use of the property at issue by any of the uses permitted in the relevant zoning district. 2, that Diversified will suffer irreparable injury if unable to proceed with their proposed site plan, which is currently precluded by the temporary moratorium, unless you should be granted this administrative relief. And three, that it would be unreasonable and unjust not to grant Diversified the relief requested. Okay? So in terms of the application that you filed, you note that Diversified now owns a 9+ acre parcel of land referred to throughout the application as the Stonegate property. That's SBL 4-1-66.2. Diversified purchased the Stonegate parcel in May of 2018 for $1.6 million. And at the same time purchased the site plan that went along with that to build an 81-unit multifamily development on the Stonegate property, which had received conditional site plan approval from the planning board back in March of 2013. My questions to you with regard to the Stonegate property are number one, who was the prior owner? Was it Little Britain Development Corporation, LLC? Tony Fine, whom Diversified made that purchase?
Yes, I believe so.
Yes.
Okay. Can you tell the board when it is that Diversified entered into a contract with Little Britain Development Corporation for that purchase?
I believe that may be in Nick's affidavit. Nick, do you remember off the top of your head?
I don't, John, and I don't have a copy of the contract here in my home office, so we'll have to follow up specifically with those dates.
So just so it's clear, I'm not looking for an exact date. If you can even tell me what year it was and perhaps whether or not it was, for example, the spring of 2016, the winter of 2017, if you're able to provide me with a response to the question in that manner, that would be fine.
Well, the purchase was in May of 2018, and that's when.
I know that was in
Yeah,
the application.
So I believe the contract was signed, but I frankly don't, I'm not sure of the relevance, but we'll certainly get you the details. And Nick can add if he recalls, or we're not trying to hide anything. I wasn't involved in that transaction. I'm the land use attorney.
Yeah, John, I don't have anything here. I'm sorry, David, I don't have anything here that identifies that time frame. So we'll have to get back to you with those dates.
Do you know whether or not you first entered into the contract within a year of ultimately, fully executing that contract and purchasing the property? Or was it longer than that even?
It could have been longer than that. It was probably in the 12 to 18 month range, approximately.
And do you know, Nick, you can answer, John, you can answer. I'm not sure you would know the answer since it sounds like you may not have been involved in that at that time, but do you know when you started talking to Little Britain Development Corporation and Tony Fine with regard to your interest in the property? Tell me if it was 2016, 2017.
Yeah, I'm sorry, David. I don't have any of the correspondence here in my home office in that regard, but there's certainly lots of information that we could provide in terms of the timing, emails, correspondence, meetings, contract dates, etc. as a follow-up. Happy to provide all those details.
So we have established that Little Britain Development Corporation owned the Stonegate property for which the conditional site plan approval was granted in 2013, first of all, right?
Yeah.
Okay, and we agree that the Stonegate parcel was zoned planned industrial at that time, but it was located within a senior overlay,
Yes.
senior citizen overlay? Okay, and final site plan approval was not obtained in 2013. It was conditional site plan approval, right? No final site plan
Yes.
approval at that time. No final site plan approval in 2014, 2015, or 2016, as far as you know?
The approvals have been extended, most recently by the board when it came out of its hiatus, I believe at the either the April or the May meeting of this year, it was extended another year by the planning board. So the approvals are
Okay.
conditional, but they've been extended each and every year since.
Okay, it had been extended on a number of occasions, first by Little Britain Development Corporation when they were the owners of the property, and since Diversified has sought and obtained.
And I would just add in to correct that in 2013, at that approval, there was, I believe, an amendment to the zoning. So it was no longer a senior overlay. There was a provision in the zoning that allowed the conversion of a senior project to a market rate apartment project. So when it was approved in 2013, it was amended from the 84 unit senior project to an 81 unit market rate project.
Okay. So in 2016, the town repealed the senior citizen overlay, but you're saying that it wasn't approved and the units weren't going to be constructed as, fitting under the senior citizen overlay during that time? It was now market rate?
Yes.
One condition of the site plan approval for the Stonegate property when it was first granted to Little Britain Development Corporation was that they signed a developer's agreement with the town, correct?
Yeah, that was one of the conditions on the site plan approval that's been extended. Yes.
Okay, so you noted that in your application, and I have searched through my office files anyway. I can't find a developer's agreement that's ever been executed with regard to the Stonegate property and that conditional site plan approval. Are you aware of whether or not?
My understanding is it may not have been signed. It is conditioned, and Stonegate has, DP has committed that as part of its review of the modification and an extension that it would abide by and sign that agreement, which would obviously have had to been modified to include the additional parcels and any other conditions that the board may implement.
Had there been any talk with anyone from the town as to what, if any, additional items might be required for the new site plan that?
We committed to continue to build the sewer pump station that was necessary, that would improve the sewer flow that was included on the Stonegate parcel. The town board approved the sewer allocation for the extension on the recommendation and the allocation pursuant to the contract that the town committed to with Mudna, committed to provide 600,000 gallons of allocation. DP has paid a down payment. The allocation that they received, the town board acknowledged that allocation. We weren't able to get to the finalizing of the agreement because the planning board meetings were suspended. We were going to get approval in all the conditions, but one of the conditions in the draft that we provided to the planning board was the recertification and amendment of that application.
You or Diversified filed a site plan application to revise the project in June or July of 2018, is that correct?
Yes.
Had there been any discussion between June or July of 2018 and now with either the town attorney or anyone else with the town as to how that development agreement would read?
Yes, there were conversations with Mr. Blythe.
Mr. Blythe left in September of 2018, right?
Well, yes, that was at the time the allocations were approved and signed in February of 2018 for the sewer.
there any writings to the effect of whatever conversations you had with Mr. Blythe? Because again, I have not been able to locate any.
I don't believe there's anything in writing.
Okay, and I've been in Mr. Blythe's position since
Yeah.
October of 2018. Has there been any attempt to discuss with me a developer's agreement?
We were in the process of finalizing the modification with the planning board to comply with seeker, so then the board could vote, because as you know, the lead agency was coordinated, the town board is an agency, and the seeker was coordinated with the town board, so the planning board would have had to adopt the neg deck before the
Before what? I'm sorry, you cut out there.
before any modified agreement was finalized.
But not before any discussions could have occurred, correct?
Discussions were ongoing and we were committed to the same terms. I mean, if that's, you know,
Correct me if I'm wrong, but nobody, not yourself nor anyone from Diversified or anyone on Diversified behalf, as far as I know, ever reached out to my office while I've been there since October of 2018 until now to discuss a developer's agreement.
no, that's the modus operandi of the board had been to comply with the same terms. The same terms would apply to additional units. The planning board and the engineer had confirmed that the pump station approval, the pump station would serve the project as existed. The other provisions of the agreement, the applicant had committed as part of the seeker review for traffic to commit to continue to participate on a pro rata basis for any traffic improvements related to a traffic light when and if installed by the town. So those were all discussed as part of the planning board's review of the project and would have been available to the town board. So those conditions would still have applied to the Stonegate development, to the Stonegate as modified and extended.
Okay, moving back to your application, Diversified is, as stated in the application, the contract vendee of two parcels adjacent to the Stonegate property, the lease and Scheibel parcels, correct?
Yes,
Fair to say neither of those parcels were included in the conditional site plan approval first obtained by Little Britain Development Corp. in 2013, right?
that's correct.
And neither parcel was added to any site plan related to the Stonegate property and submitted to the town planning board until after Diversified purchased the Stonegate property in May of 2018, correct?
That's correct.
Again, per Diversified's application, the Stonegate lease and Scheibel parcels were rezoned from planned industrial to R5, which included multifamily residential in February of 2018, correct?
Yes, that's correct.
Okay. When did Diversified start talking to the owner of the lease parcel about purchasing that property? Approximately, again, I'm not looking for an exact date.
It would have been at the same time in the Scheibel property and Nick's original response, 12 to 18 months before the purchase. So they were talking at that time.
12 to 18 months before the purchase
Is that
of
correct, Nick?
the Stonegate parcel?
Yeah, yeah.
Somewhere approximately in that time frame, it was looked at as a possible expansion of the Stonegate property to include both the Scheibel and lease parcels.
Okay, and when did Diversified actually enter into a contract to purchase the lease parcel? Again, I'm not looking for an exact date.
Yeah, again, I don't have that information handy at the moment, but we can certainly provide. And it's an option, not a contract, technically.
What does that mean exactly then?
It's an option to purchase, not a contract to purchase. Different than the Scheibel parcel. There's a contract, there's a purchase agreement. Purchase Scheibel, there's an option agreement to ultimately purchase the lease parcel.
Okay. When did Diversified start talking to the owner of the Scheibel parcel about purchasing that property? Was that also be 12 to 18 months approximately before the purchase of Stonegate?
Somewhere in that general range, yes.
Okay. And Diversified then entered into a contract as opposed to an option to purchase the Scheibel parcel?
Correct.
What did Diversified agree to pay for the lease parcel?
Again, I don't, had we known we were going to go through these particular items, I would have had all those documents available, but don't have it here in front of me tonight.
Give us an approximate.
Approximately $400,000, somewhere in that range.
What did Diversified agree to pay for the Scheibel parcel approximately, if you don't know the exact amount?
Yeah, I don't recall those numbers specifically.
You can't even give me an approximate on that one?
No, I'd rather not. I'd rather use real numbers. Happy to provide it as early as tomorrow.
Was there a down payment made on either parcel?
There are option fees that were paid on the lease property and a contract deposit on the Scheibel property with ongoing carrying expenses for expenses of the property owner.
What were the option fees paid on the lease parcel?
That I might be able to tell you by looking at some of the financial information I have here. Looks like the option fee is $5,000 on the lease parcel.
That's a one-time fee?
That was a one-time fee at the time we signed the option.
Would that be returnable to Diversified should the contract not, or it not proceed to contract?
No, that's a non-refundable fee.
And you mentioned carrying costs on the lease parcel as well?
We don't pay carry costs on the lease parcel, David. We pay them on the Scheibel parcel.
Was there a contract deposit? I believe you actually acknowledged that there was on the Scheibel parcel. If so, how much was that?
There was, and I'm not sure that I'm showing that here. Just give me a second. I'll see if I can. We would have to confirm this, but it looks like it was $25,000.
Is that non-refundable as well?
I believe that's non-refundable at this point. We're out of way past the diligence period of the terms of the contract.
Might it not be, since you said you believe? Are you not
It might.
certain?
Yeah, I'm not certain. I would have to
You
review
might be
that
able to
document.
recoup that? If unable to complete that purchase, you might be able to recoup that? You're just not
Possible.
sure, I get it.
Yeah, I'd have to
Okay.
look at that.
You mentioned carrying costs as well with regard to the Scheibel parcel?
Yes, we pay their reimburse them, I believe, for their real estate taxes. It's non-refundable.
A figure on that? What you reimbursed them for to date?
Um, somewhere in the range of about $12,000 or $13,000 approximately.
Would those be refundable to you if unable to complete the purchase, or no?
No, they are not.
Per your application, the rezoning of February 2018 was not done at Diversified's request. So
That's
while I
correct.
understand, right, so while I understand that there may not have been any formal petition filed by Diversified or on Diversified's behalf, did Diversified want those properties rezoned?
I can answer that. Certainly Diversified and able to do a multifamily dwelling based upon the 216 referral, and that's in my presentation. Once I get to that, yes, they would have preferred this property to be zoned multifamily, so they wouldn't have to develop a warehouse or an asphalt factory. And I would contemplate, and it's in the application, and I will be presenting the fact that the comprehensive plan that was adopted designated not only the Stonegate parcel, but the Scheibel and the lease parcel as being residential. Your engineering consultant and the planning board attorney, when the planning board reviewed this, because it was a zoning amendment that did have to go to the planning board and was discussed at the board meeting, discussed that this was part of 3 or 4 other amendments to the zoning code that were contemplated in bringing it into compliance with the comprehensive plan. So when the town board adopted the overlay, deleted the overlay in 2016, they had an infrastructure committee. That infrastructure committee was talking, including examining sewer and water, reviewed zoning, made suggestions to bring it into compliance. And I believe as you'll see as I go through the presentation, that it was contemplated, that the attorney for the planning board acknowledged it, the planning board chair acknowledged it, and the engineering consultant for the planning board, who's also the engineering consultant for the town board, and also was advising the infrastructure committee, all advised that this was part of cleaning up the zoning code to bring it in compliance with the comp plan. So any allegations that have been made that this was some kind of, done deal is belied by the facts of the matter. This was done. Leaving this as planned industrial was not contemplated. It was never discussed in the comp plan. There was nothing in the town minutes. Made the change in 2016. They did it in acknowledgement of the fact that there was an approved residential development, and allowing this for planned industrial made no sense from anyone's perspective.
So again, per the application, it appeared as though Diversified was advising the board, again, that this change was not made at their request. They had nothing to do with it. They did want the zoning change to go forward. And it would be fair to say, would it not, that they would have let somebody on the town's behalf know of what their desire was?
Just as anyone or any property owner or any resident or any citizen of the United States can make a board know what they prefer. I think as your board has been made aware by some of the neighboring residents that they would prefer there not to be a development there. But the fact is, the board did it on its own volition as part of the review and contemplation of its comprehensive plan. People may not agree with it, but they went through the procedures. They went through it correctly. It was not on application of DP, and it was done in contemplation of making it comply with the comprehensive plan, because the prior zoning, it was adopted in 2016, did not comply with the comprehensive plan. So this brought it into compliance. It was done in accordance with the law. It was not challenged by anyone. who had an issue. It was transparent. It was open. It was commented on by the infrastructure committee and the planning board. So was the DP and Mr. Manoia happy that it happened? Sure. But that doesn't mean they wrangled something through or applied or made it or caused it to happen.
Diversified is not a novice when it comes to developing properties for multifamily residential use, correct?
No, and we will present that, and Nick will present his track record in a few moments, hopefully.
And in fact, they're very familiar with all the municipal processes and procedures a developer must go through in order to move a development like that, that they're looking to move forward here in New Windsor, correct?
Yes, they developed a project in New Windsor that's very successful, as Nick will discuss in a moment.
So diversified, you don't disagree with me with when I say that they knowingly took on and often take on significant risk in trying to get development projects like this one to the finish line, given their substantial experience in doing so before in New Windsor, as you mentioned, and elsewhere?
Every project has risk. Yes, I mean they knew what they were up against, but I think as you go through the town in adopting a moratorium, we will hope understood its risk in ignoring the fact that during its procedure, DP has acquired constructive and actual vested rights in its approval.
It's a legal argument to be
That's a
made,
fact.
and again, not subject to this proceeding here now.
Well,
So
you're
again,
trying
I'm
to
just trying to
risk.
figure out some of the facts.
All parties in a deal have risk.
Understood. Per the application, Diversified entered into a contract to obtain sewer service for the project from Mudna. Right.
Yes.
Do you have a copy of that contract? Because it wasn't included in the application. And again, I don't have a copy in my office files.
I don't have a copy on hand, but if you want a copy, I mean, it should be in the office files, but yes, we'll supply it.
How much did Diversified pay to Mudna under the terms of that contract?
I think there was a down payment made. Was it 32,000? Is that what
I might have that here, John, in some of the financial records. If you hang on just 1 second, if I can pick that out. Again, without digging in, getting granular in the details, it looks like $44,000 has been spent to date.
Was Mudna represented by counsel in connection with that contract?
Yes.
I don't know the answer to that.
I heard somebody say yes. So who was counsel
Yeah.
for Mudna?
I believe it was Jared Jacobowitz.
And Mr. Jacobowitz is a partner in the law firm of Jacobowitz and Gubitz, correct?
Yes, he is.
John, you're a partner in that same law firm?
Yes, I am.
Were you partners in that law firm at the time that Diversified and Mudna entered into the contract?
If yes, and at that point, it would have been disclosed to all the parties, and that was a contract.
And were you representing Diversified at the time?
We hadn't had an application in there, but we've done work for Diversified on other applications in the town of Newburgh.
No, what I'm asking you is if you were representing Diversified in connection with this project at the time that the sewer contract was signed.
It's possible, but I don't know the exact timing. The
Do you
application.
know if you were representing them on that? Nick, did you have counsel when you signed that contract?
Did I have counsel representing me? Is that the question? No, I did not.
All right, per Diversified's application, it says that you incurred a number of costs totaling over $775,000 in connection with this particular project. It was not broken out. You did list, for example, that there were expenses incurred with regard to the contracts for the extension properties, which we went over a bit, application for the land use approvals, engineering for plans, and so forth. There's a bunch of things. Could you break that out for us? Not tonight, perhaps, but in the following days. We are going to be accepting comments for 10 days after the hearing as per the notice.
The actual amount as of today is $867,000.
I can't hear you.
Can you hear me now?
Can't hear you, Nick, sorry.
He said 867,000. 867.
Can you hear me? Can you hear me now?
Yeah, he's coming through. It's got to be you, Dave. How about now, Dave?
David, can you hear me?
I've got technical difficulties. Can you guys hear me? Just shake your head, yes or no? You can? All right, I can't hear you at all. So, Patrick, you there? You got any suggestions? You can text me. Should I log on, log off, and log on?
Yeah, try that, Dave. Try to reconnect and see if that redoes the sound.
Patrick, I don't think he can hear you.
Jesus Christ. Yo, what's up?
Yeah, he said log off.
All right. Just give me a sec, guys.
While we're on a little break here, you're breaking up a little bit. I don't know if you can talk closer. Some of your words are dropping. That's all.
All right, sorry,
Okay.
it's storming here in Walden. I don't know what it's like.
Yeah, as it's doing out here too, so maybe that's doing something.
All right, I'm back. I can hear you. Can you, everybody hear me?
Yes.
Okay. Yep, I'm good. Thank you.
David, can you hear me now?
What's that?
David, can you hear me?
Yes, I can.
Okay, the amount
Can you hear me?
as of today is $867,000. 867, 639.94.
All right, are you able to break that out for us?
Absolutely.
Okay,
Give it to you any way you want to see it.
that's fine. Just give it to us in the next couple of days if you can. Following along, I guess, the outline that you provided in the application itself.
That's actually, that's the cash amount invested. It's also subject to a mortgage, about $1.5 million. So we've invested about $2.3 million, round numbers.
As the current owner of the Stonegate parcel, Diversified has the right to proceed with the plans as conditionally approved by the planning board in 2013, as long as they meet whatever conditions were imposed at that time, correct? Can we agree on that?
I agree we can proceed. I don't know. But I would reiterate, and once again, I would go through that at the request of the town, in order to assist you in the town in complying with an order from the DEC,
No order. If we could just stop for a second there, because
there was an
there
order
was no
to-
order for the DEC. No,
well,
you can continue, but there was no order.
there was a requirement that
There was no requirement.
then the town, well, we will look and confirm, but there were 15 property owners who had contaminated wells. The town board
True.
Nick and DP because they weren't able to find an easement to be able to hook those folks up to town water.
Yeah, so then, David, why was I asked to meet with the DEC about putting a water line through my property? Which I
I'm
did.
not going to get into a debate. I'm not going to get a debate about it here. I'm just correcting, a statement that was made on the record that's happens not to be accurate. So
Okay.
the answer to my question initially, whether or not diversified
Yes,
could
well,
proceed,
the answer
with the conditionally.
The answer is the property has been modified to install that easement that was designed in the best location that would incur the least cost for the town to install it and save the taxpayers money. So the project as approved would have a unit or two or more on that water line. So it would be required based upon actions that the applicant took in conjunction and reliance upon the request of the town to modify that approval.
There's nothing keeping from diversified from trying to do so if they wished, correct?
I don't know if you can modify. You guys would have to tell
Well, have you asked?
that we can modify the approval, but we will, at this point, that would be something to keep in mind. But the cost incurred to date, based upon the legally adopted zoning of the town and the request to modify, I don't know if that would make it cost effective, but that's not that is part of why we're here, and we'll demonstrate it if that's the question.
Okay, John and Nick, I don't have any further questions for you right now. You can make your application. George, I would just ask that before you close out the hearing, you give me another opportunity to highlight a number of factors for the board that should be considered when it does come time for you to ultimately get together and make a decision as to the application, okay?
Okay, so the attorney for the developer now would make their case? Off you go.
Yes, and I will do my best to make it as brief as possible, but as you can see, Nick has spent $2.3 million. This is his opportunity to present this to the board and introduce himself. So I will talk as quickly as possible. I would note that we just were questioned for 45 minutes, so hopefully the board will indulge us a bit.
Fair enough, let's go.
Yeah, I'm here with Nick Minoia. Nick's the one of the managing partners with Diversified LLP. They're the applicants, as Mr. Zagon has explained. Our application consists of a hardship application as well as affidavits from Nick, affidavit from Anthony Nestor, who was with the consulting engineers who prepared and assisted and represented DP through the project. Phil Greeley with Mazer Consulting, who is the traffic consultant who addressed the concerns of the DOT and prepared acceptable mitigation for the traffic. And from Joseph Lonaro from Chazen, who as an independent party who was not involved in the approvals, took a look at the sewer and water issue and provided an opinion on those. What we intend to demonstrate, I heard Mr. Zagon go through his presentation on what we have to demonstrate. I'd like to respectfully agree that that is what is in the code, but we believe that based upon the moratorium as written, we're legally exempt from it based upon the record of the proceedings that we have actual and constructed vested rights to proceed on the action. As was discussed in our questioning from Mr. Zagon, Nick and his group granted easement rights to the town acted upon wetlands permits and allowed a water line to be constructed by the town, which line would serve not only this development, but would also alleviate a contamination issue with town residents and save the towns a tremendous amount of money. Believe that easement was valued at about approximately $100,000 over the applicant's property and through the permitted wetlands. As was stated, we received and obtained commitments for sewer. That was acknowledged by the town. The town separately had an agreement with Moodna that they committed for 600,000 gallons of allocation to Moodna. So the town is committed to provide that beyond and above any other commitments. The applicant financed the land use approval process. So, and we believe that the applicant stood ready to obtain its approval prior to this new board taking office and would have attained that approval but for the actions of certain people to cancel meetings for no defined reason other than a request to frustrate my client's due process rights to present and pursue its application. As for the criteria, what I would point out that it's impossible for us to provide by dollars and cents proof that we can't get a reasonable rate of return for anything that's permitted in the zoning code, because what we're applying for is permitted in that zoning district. We have a complying plan. So your criteria, I don't know where you came up with it. I can only conclude that the criteria would mean we would have to put dollars and cents proof that we could not get a return on our investment if we put a single family or two family home on the 14-acre Scheibel property or a single family home on the lease property, because that is all that's permitted under this moratorium. We're asking relief from the temporary moratorium, not relief from the underlying legal zoning, which we comply with and are fully ready to go and acknowledge that we would get a reasonable rate of return. Anybody who asks you for any relief under this moratorium is likely has an application in for a permitted use. So how could you provide evidence that you're not getting the reasonable rate of return? So the standard is makes no sense. We believe we've provided, and we will supplement with the detail that we've invested $2.3 million and made other substantial commitments to this application and would not be able to get a return on investment. And frankly, it's just unjust. I mean, there was talk about what happened in 2018. Nobody has made any indication that anything that happened with that zoning was illegal and untoward and didn't go through the appropriate process. I think the facts belie that determination and will show that Nick worked with this town, met with the applicants, took all the procedures, expended significant money, and was at the finish line at the close of the October hearing, had a final meeting with the engineering consultants to address the issues. We submitted the approval documents for review for a conditional approval, and then all of a sudden the meetings were canceled. I would give that for you Democrats on the board, if you recall Merrick Garland. You may not agree that he was qualified, and people may have disagreed that he should have been on the Supreme Court judge, but I believe most people understand that he should have had the opportunity to have a hearing and to been heard. That's exactly what has happened here. The cancellation of those meetings in December and both January meetings deprived Nick, without any public hearing, without any adoption of a local law. And when we're talking about transparency, that's the issue here, is we weren't allowed to proceed to finalize those agreements because prior to adoption of the moratorium, there was a de facto moratorium by canceling the meetings and depriving the applicant of its due process rights. So we believe that we're entitled both under the theory of vested rights and under the theory of Section 5 of your moratorium, that because of those actions, we've been irreparably injured, and it would be unreasonable and unjust not to let us go forward to try to obtain our approvals. Now, Nick will testify, and his affidavit provides dollars and cents proof, and will provide more with the details that you want. So now I'm going to go to the history of the property, and I think this is important. A lot of it I said in my answers to Mr. Zagon, but the Stonegate parcel was industrially zoned, but it had an overlay. And at that point, the town, after adoption of its comprehensive plan in 2009, had overlays which allowed for senior housing, 9 to 14 units per acre, depending on how many affordable units you provided. If you were totally affordable seniors, I believe it provided up to 18 units per acre. And if you were workforce housing, it was 10 units per acre. That attached to the Stonegate parcel. And during that time, when the comprehensive plan was adopted, it designated these properties, acknowledged they were in the water and sewer district, and that they should be in the water and sewer district, and designated them as being appropriately changed to residential zoning. So the action in 2016 that ripped out the overlays essentially said this is the planned industrial. Now, as much as when Mr. Zagon talked about savvy developers, I've been around enough to know that if I was representing someone who was putting a warehouse or a factory or a manufacturing facility on this property that people are concerned about a residential development members of your community, they would have a much bigger problem when the lot coverage was 85% in many areas of your planned industrial resolution. So in February 2018, local law number 1 of 2018 was adopted. It included several provisions to bring the town's zoning into compliance with the comp plan, not only as it related to the DP process. It got rid of the casino overlay. It changed another property in the town from LC to R3. It cleaned up some languages because your code, for some reason, didn't allow heliports in an airport zone district. So it made cleanups. Now, that law was recommended and reviewed by the town's infrastructure committee, and the chief concern of that infrastructure committee was sewer and water issues. The minutes of the October 25th, 2017 planning board meeting disclosed that the attorney from the planning board described as a law seeking to define and correct some bulk tables for the AP zone, as well as change a few zoning designations. The planning board chair then turned to the engineer and said, "We discussed these, right?" And he said, Mr. Etzel said, "These are all items that were discussed at the infrastructure committee for the ongoing cleanups on the bulk table on the zoning map. With the elimination of some of the overlay zones, I believe this considers the R5. He went on to say there's an area where which is R5 development, that's there by virtue of the overlay zone, which is now gone. So he said, now you are creating an R5 zone in that area that was previously developed under the overlay zone. So a number of cleanups of that sort. They're all, to my knowledge, discussed at infrastructure based upon input from various departments. Ms. McMillan, the planning board attorney, concurred. She said this amendment is one of a number that are currently in front of the town board for the last year or so. We have been doing these periodic amendments, like Mark said, to update the code. So that totally belies any discussion that there was some kind of quid pro quo. And even if there was, it was illegal. I mean, you can request a zoning change, especially when that zoning change is in compliance with your comprehensive plan. But it's pretty clear what the thought process was for the board, and that that it was adopted in a very transparent manner. No one challenged it, and it was a legally valid zoning. And upon that, DP went forward, granted the easement to the town, purchased the property, expended a lot of funds, and started going through an 18-month process. Now, that brings us to DP.
John.
Yeah.
John, could I just interrupt you for 1 second? You're at the 10 minutes allotted, so can you give us an idea as to how much longer you would need to complete your application?
Unmute.
Yeah.
Hey,
Yeah, I'm
Dave?
gonna let
Now,
Nick
listen,
go
you
through it.
made-
Give me 5
John,
minutes.
my-
Yeah.
Hey, John, you made a good point before about the 45 minutes, Dave. You made a good point. So go ahead, John. You go.
Okay.
I'll let you go on.
I'm going to introduce Nick, and we submitted some photos of what Diversified does. And as Mr. Zagon mentioned, they are savvy developers. So I want Nick to briefly discuss, what the type of project this is, who lives there, because part of this, we believe the impetus for a moratorium and discussion, a lot of mischaracterizations that were made about this project and about the facts. So we're here to clear up this fact, clear up the record, and open up a dialogue. So Nick, I'm going to turn it over to you.
Okay, I was on mute. I unmuted. Can everybody hear me?
Yes.
Okay, thank you. Okay, so I'll try to be brief as well. I know everybody's got a busy schedule and these calls are not easy to deal with. So real quick, my background is about 35 years in the development experience, mostly building multifamily. Long before it became kind of the current rage by developers, I was involved in the development of multifamily in the Northeast. So that experience transcends the development process, which is what we're talking about here at the front end, land use approvals, construction management. I have a diploma in construction management from NYU. We do our own leasing, and then we do our own property management. My career spans the development of in excess of 10,000 multifamily units over that 35-year period of time. So in the local market, we have, I was born and raised in upstate New York, by the way. I'm from Binghamton, New York originally, residing in New Jersey, which is kind of the core of where we operate. Our biggest footprint, frankly, is in New York State. Our projects in New Windsor, the town of Newburgh, Hyde Park, New York, Yorktown, Sleepy Hollow, New York, etc. So we have a very large footprint in Orange, Westchester counties, and our prominent part of our business is multifamily construction. Although we also have we own office buildings, retail, and industrial, as well as self-storage properties. So we've got a very broad experience in real estate development, and we've been doing it for a long time. In particular, I want to bring a couple of things to the board's attention regarding the New Windsor development that we have, which is known as Summit Terrace. I think John Capello had previously provided photographs of not just our Summit Terrace development, which I think most, if not all of you, are aware. It's at 1000 Clark Street, just off 207 Little Britain Road. It's 270 multifamily units. We don't do affordable housing, by the way. It's all middle market type housing for where the market has really gone over the last several years, which is empty nesters, move down type renters, and millennials who are young families moving up. We did some statistical analysis on the 3 properties we have in your local market. That's Summit Lane on Stewart Ave, on Drake Drive off Stewart Ave in the town of Newburgh, Meadow Ridge, which is on Meadow Hill Road in the town of Newburgh, and Summit Terrace. The combined total is 643 apartments. New Windsor, the Summit Terrace project, is 270 apartments. Very interesting footnote is the very high percentage of first responders that live at these communities, which I thought you'd be interested to know. At our Summit Terrace community, keep in mind that there's 170 apartments there. 98 of them are occupied by what I would consider first responders. There are 22 military families there, 25 medical related families, 15 police officers or correction officers, 7 town employees that work for the town of New Windsor, 1 postal service employee, 12 government employees, and 16 teachers. So these are not people from like another place. They're from your place. They live and work in your community, and they are the people that support, the families and the services in your community. At Summit Lane, which is probably 3 miles from the border or less, 2 to 3 miles, there are 43 of these first type responders. living there. There are 14 military, 7 medical, 7 police officers, and 15 teachers. At Meadow Ridge, which is also in the town of Newburgh, again, both of these projects are within 2 to 3 miles of the border of New Windsor. There are 9 military, 8 medical, 2 police, 2 firemen, and 16 teachers, for a grand total of 178 apartments occupied by what I would consider first responders, medical, police, fire, and teachers as well. On an average, interestingly enough, Summit Terrace has the highest percentage out of our 3 properties of those types of families. 36% of our tenants fall into that category. The average between the 3 communities is 28%. So out of 643 apartments, 178 of them are occupied by first responder type people, teachers, firemen, police, and the people that work in your municipal building. Couple of other footnotes. In 2019, I paid $968,000 in real estate taxes for Summit Terrace. And when we built the project, I paid $945,000 in rec fees, just as again, as a good neighbor, as a solid citizen, project that has never had any issues whatsoever in terms of crime or any related issues. These are communities that thrive as a result of the needs of the local community and the lifestyle that people are looking to provide for themselves and their families. Again, touching on the numbers, we've invested slightly north of $2.3 million in this project over time, including the actual cash, equity, and the debt that we have incurred. And we are most interested in trying to continue to pursue what we think is being a good neighbor, a solid citizen, and providing a diversity of housing for your community. That's all I have, John, unless I missed something that you think I should bring up specifically.
No, thank you.
At this point,
Am I back on now? And I will go faster, right? Because a lot of what I need to say now has been said. Nick was going to go through some of his financials, which will supplement the negotiations with Moodna. And, David, as we're talking, Moodna, there are set contracts and fees. And I would reiterate, because when I was talking to you, we are DP's land use attorneys, not general counsel for DP. They make their deals. They come here, we assist them with approvals and in closing on the properties. We are not general counsel for DP. But once zoning was done, they redeveloped the project, significantly reduced the grading, and came up. At that point, we're looking for 195 units to be consistent with the zoning for the Stonegate. So it would be an additional whatever 81 plus 195 is. We went to the planning board meeting. We referred to the ZBA because we would have needed a variance to go 9 units per acre. We had a public hearing at the ZBA in November of 2018, where the public attended and began raising its questions. In response to the public comments, we provided greater buffers, reduced the units to 192, met with the engineer and planning board to discuss seeker compliance, appeared at the ZBA with the revised plans. There were still concerns. At that point, DP decided to withdraw the ZBA applications and reduced it to 172 in compliance with the zoning, so no area variances were needed. I would note, if DP had such control over the town board, when the town board adopted the zoning, if DP had its druthers, it would have been 9 units per acre instead of 7 units per net. So that further belies any, allegations that DP somehow was in control of this. We went back to the planning board in July 2019. At that point, we supplemented reports with traffic from Mr. Greeley. There's a full affidavit from Mr. Greeley, who's one of the most noted traffic experts in our region. Has probably been practicing over 40 years, developed most of the projects that you see in this area. He met with the DOT We have a plan that we believe has been signed off by the DOT to address any traffic concerns, which is one of the reasons for the town's adoption of the moratorium. We submitted a full SWIP, an EAF, wetlands delineation upgrade, committed to upgrade the sewer pump, did a school children analysis that showed, based upon studies, there would be a total of 64 school children here, but based upon review of the other developments that Nick did in this area would only be about 20 to 30 students. So any claims that there's an over run on your schools is also belied by the facts. In September 11th, we went back with all the revised plans. Nick and his team had a separate meeting with the neighbors outside to listen to their concerns and once again revised the plans. In October, we had the public hearing. That was the fourth meeting before the planning board. We had very detailed comments on exactly what was required. We made those revisions. Our engineering consultant met with the planning board's engineering consultant. We made a new submission, submitted all the approval documents, and that's when the rug was pulled out, from under us. Now, as for the reasons of the moratorium, Mr. Lenaro's affidavit goes through the sewer. We understand you have to make some repairs to your sewer plant. You're committed to do that. I believe, Dave, you're under a DEC order for that and have been complying with the DEC, but I want to relate that in the 17-month approval process, your engineering consultants, the same ones who prepared your report for the moratorium, did not raise an issue regarding capacity. That's because we had an allocation from the MUDA, and also the DEC, who was an involved agency, never raised an issue to say, when they got the notice of lead agencies, to say, hey, there's a cap on the sewer, we're not allowing anybody in, because they believed the DEC understood that the towns were taking steps to comply, and therefore there was no denial on that. Also, I want to relate, both as it relates to sewer and water, if everything went great, and you guys said, John, I agree with everything you and Nick said, in July, we're going to give you authorization, go back to the planning board, Godspeed. Godspeed would be at least another month or two at the planning board, then satisfying the conditions with to get final DEC approval, getting final DOT approval, although they signed off on the design. So we're talking another potentially 6 months, and then you have to build the thing for 12 to 18 months. So before any toilets are flushed or faucets are turned on, we're best case scenario, late 2021. So at that point, the town will have done a lot of work on its I&I problem. We will be past the next shut off of the Catskill Aqueduct. And as it relates to water, if you don't address the situation with the Butterhill wells, which we're more than happy to assist you in on a permanent basis, the whole town's at risk if the aqueduct goes over there. That's something that behooves the town to do, and that the applicant has and been working with the town to solve those problems. And last thing I would note on those issues, I know you saw the cover of the Record today. 69 employees were furloughed at the county because the revenues that they had projected receiving are going to be nowhere near what they're going to actually receive based upon COVID. So it would behoove the town, as you're committed to make these repairs and improvements, to have people in there that will be paying taxes, will be paying user fees, will be more on other additional properties paying the capital improvements when you have to bond these improvements, and having these people will actually help you comply rather than be a detriment. So we believe that it is fair to allow us to proceed. We have addressed the sewer. We're not impacting sewer water. We've come up with a plan that addressed Greeley's affidavit. I know there's several comments there, but those members of the public have had opportunities to speak. They've had opportunities to review the reports. There has not been one scintilla of evidence other than general complaints filed as to what this project will do. I think, as Nick testified, when people are saying there's going to be crime with these people are cops who are going to be living there. Not well, maybe it's the wrong day to say cops don't commit crimes, but it will be citizens of the town of New Windsor who will be part of the community who are looking for an alternative way to live. It's a good project. It's a project that will not result in crime. It's aesthetically attractive. We invite you again, if you haven't already, to not only look at the pictures, take a ride, go look at these developments, look at the people walking around them, and you'll see that, a lot of this is purely not true. The school children will not be generated, not overrun. There's, once again, no factual basis. So based upon all that, we believe that we should be entitled to relief here, and that it would be unfair to stop it. So with that, any other questions, we'd be happy to respond, and thank you for your time.
Okay. David, did you want to say anything?
No, George, what I'll do actually is I'll just supplement the record with the further information that I had for the board.
Okay. So at this point, before I open it up to the public, I'll just ask board members if there's any comments they want to make. And I'll start out with, I guess, Steve Moreau, you're to the left, you'll be number one. Anything you want to say on this?
Yeah, I have a letter that was written in by Steve Subak. It's addressed to Mr. Myers. I've lived in New Windsor all my life. While growing up, it was a nice, slow-growing town. I live on Clarkview Road, and the traffic is bad going through here. It's like a raceway. Yes, and New Windsor PD has been stationed on the road and pulled vehicles over and cited them, but they still speed through here. I'm voicing my concerns on putting the so-called Stonegate apartments up. This is going to cause more traffic congestion on Clarkview. It's hard enough pulling out of my driveway at times. The sewer systems are old and not able to handle the extra volume. And with our water problems, what's going on now, it seems that the project was not thought out fully by the last administration. I am strictly against this Stonegate project. Steve Subak.
Okay. I would make a quick comment here that you reference Mr. Greeley as a traffic expert, and I'm sure he is, but I would invite him to come here any weekday between 4 and 7 along Temple Hill Road in this area and drive through, and then let him tell me that there's no traffic. All right, Andrew, you have anything you want to add?
I have some couple of questions, if that's okay, Mr. Supervisor. Just as a side comment, John, I'm a little offended by the comment about the cops that you gratuitously made there at the end of your statement. So it has no bearing on how I'm going to vote, but I found the statement offensive. That aside, is it your position that there will be somewhere between 20 and 30 children in 172 units?
My position is that a report was filed with the planning board, reviewed by the planning board, based upon the studies done by Rutgers, and the studies showed that there would be 64. These studies are based upon actual counts of actual developments. We also did actual counts in the Summit project of 270 units in New Windsor and the two projects in town of Newburgh. So it is not John Capello saying it is an expert doing it based upon facts, and there has been nothing yet to refute that. Just as with the traffic study, nobody's saying there's no traffic in the area, but we're saying an engineer has taken the best evidence available as to what this will generate upon studies based upon a science, reviewed that with the DOT, and implemented a plan to address and mitigate that traffic coming from this development, which is in.
I didn't ask you about traffic. I asked about the number of children.
Yes.
So
And I just
we've been
also
at this. No,
wanted.
no, no, John, shut up for a second. It's
Okay.
my turn. We've been at this for an hour and a half or an hour and 15 minutes, and I only have a few questions, and I'd appreciate it if you just answer my questions. So my question is it the position of DP that there would be somewhere between 20 and 30 children in these 172 units?
Can I respond to
Yeah,
that,
yeah.
Mr. Regenbaum?
Yeah.
Absolutely.
The answer is absolutely yes. Those are the correct numbers based on all studies that we have and our own experience as a developer of this product, including the three local properties that we have, the Summit Terrace, New Windsor, and the two in the town of Newburgh. There are less than those number of children at those other communities. This type of product does not, by its nature, draw families with children typically.
So I'm familiar with your Summit Terrace property, and I do happen to think it's a nice property. So, but I'm not sure about the numbers on the children though.
John Capello, do you have the report there that we did? I don't have it in front of me with the number of children at the
You
Summit
can do
Terrace.
it after if you want,
Okay.
Nick. But
Okay.
what
Yes.
I would like to
And
know is in that particular property, can you show me how many kids are there?
Yeah,
we
absolutely.
we did
We have
submit
it.
the counts. There is a report.
There's a report that was submitted that has those counts.
Okay.
Yep.
And now when you talked, and this is to Nick, when you talked about an option versus a contract, what do you mean by an option agreement on the lease property?
Yeah, it's really just it's a term of art, so to speak. There are options to purchase, and then there are contracts to purchase. Essentially, you get to the same place. An option, has an outline, a letter of intent, if you will, outlining the terms of a purchase agreement, but it's not a purchase agreement. Purchase agreement would have much more detailed language in it regarding, reps and warranties and so on and so forth. Typical contract that you would have, whether it's for inspections, environmental, and so on. And an option agreement, in its simplest form, says we're going to buy the property within a prescribed period of time if certain events happen for X dollars.
Are you bound by that option agreement? Like as I would understand the contract, that you've made certain agreements and you've given certain consideration in order to have that contract. And I would assume in regards to a contract, that consideration would be money. With regards to the option agreement, is there something that has been exchanged in order to have that option?
Yeah, there was consideration for that option. We've paid option fees. The only one that I saw, and again, what I have here may not be 100% of all the records, but I see here one option payment for $5,000 to John Lease for the option agreement, and those monies are non-refundable. So that's just money out the door. There may have been other option payments, but I'm aware based on the report here that we made at least that one payment.
Does that option agreement have any time contingencies to it?
Yes, it does.
Do you know what those Okay.
I don't have it in front of me, but there is a sunset provision that they refer to it where the option essentially expires.
You don't know what that is right now?
I don't have that with me.
You could submit that to David at some point?
Absolutely. I'll make note of that and we'll submit that as well.
Okay. And the last, I think, questions I have are this discussion of the MUDNA partners or MUDNA agreement. What that's referring to purchase of sewer points, is that correct?
That is an agreement to purchase the sewer capacity necessary to operate the number of units at this community. Yes.
Okay. And that agreement is non-refundable? I was trying to keep notes on what you were answering with David.
Yes, those monies are non-refundable. So those dollars, and I see here, it looks like I paid a 25,000 and another 18,000. So it's $43,000 to $44,000 that I show on the report that I have here. This may not be all of it, but those monies are gone. There's no refunding of those monies.
Okay, and so those monies buy you for sewer points, which buy you sewer capacity,
Yeah,
fair?
it's really a reservation of rights. Effectively, these sewer agreements tend to have it's an agreement to reserve a certain capacity, and you pay the money, and hopefully you get to use it. If you don't, you lose your money.
Okay, so I think the last thing that was discussed, or in John, in your statement to the board here, you said there's going to be no effect on water, sewer, and traffic. So what I'm trying to reconcile in my head with that statement is obviously the need to purchase sewer points anticipates the need that there is an effect on
Yeah.
sewer by a project of this magnitude. How that effect is handled is a different thing, but to say that there is no effect on sewer is not a fair statement.
Yeah, I was rushing through to try to get the time. I mean, we went into detail in Mr. Lenaro's affidavit. My point was that the town has committed to Moodna to allocate 600,000 gallons of that capacity for Moodna to grant to people. DP purchased 35, actually purchased 42,000. That's the allocation the town approved. And I believe you were on the board when they approved it on the basis of your engineer saying it. At that time, there wasn't any discussion to say, and that was not that terribly long ago, that, hey, we don't have any capacity because you had committed to give that capacity to Moodna. And my other point was that in context of when a toilet will flush on this project, you will have to already have begun the repairs that you've agreed to as part of your consent order and part of your negotiations with the DEC to involve. Therefore, it can handle the capacity that this project is generating. That's the point we made, point that was made by Mr. Lenaro in his affidavit. That's the point we believe what DEC, when they were in the involved agency, didn't say, hey, this project can't be approved. They didn't comment it because they acknowledge you are working towards solving your problem and that the users and the money you would get from this project would help pay those capital costs of those improvements and provide more users who would be paying fees to use that capacity that will be generated by fixing your I&I problem and improving your sewer plant.
Okay. That's all the questions I have, Mr. Supervisor. Thank you, John and Nick, for answering my questions.
Thank you very much. And I didn't mean to be flip with my comment. I was just
I appreciate that.
trying to, I appreciate every police officer, especially in Windsor and in Orange County, and they've been doing a great job. And I certainly support them and
I also made a
want to provide housing so they can live in your community.
Okay, I also made a note to myself when you made that comment. I wasn't sure where you were going, but we have a very capable police department here. And in my opinion, and I've been in that business a long, long time at pretty high levels, it is the best police department in Orange County. But that being said, we do not need any help from any policeman who happens to live here. So it actually creates problems if they think they're helping. They cause more problems than they help. So you have to be in that business to understand how that works. So I appreciate what you're saying. I just didn't get where you were going, but it's okay. I just think that didn't need to be brought up.
Yeah. Well, I mean, our position is that's the type of people who live in this development are people who work in your community, are hardworking, and will serve. And that's based upon evidence of who lives in the existing one. Versus your.
But just that you should know, off-duty police officers sometimes cause more trouble than they help.
You have to talk to Mr. Regenbaum on that. I'm not going to make any
No, but you
comments about that.
John, you brought it up. Okay, so let's go to Councilman Bedetti.
Hi, how are you? I do have a few things. So yes, I do take offense to that comment about the police because I happen to be one of them. So I know you clarified what you did. That's fine. And just for the record, I started on the board on January 1st, 2020. No time before that. However, I was interested in the Stonegate project. I met with, I believe, Nick, I guess it's going to be directed with you, with a bunch of concerned citizens who were going to be affected by this project. I did ask one of the questions at that time during the meeting we met about the zone change. And Nick, if I'm not mistaken, you adamantly denied it had anything to do with it. I had nothing to do with it. I didn't ask for it. I know there were several residents there. Just so we're clear here, I have a letter written by you, I'm not going to read it, in July of 2017, confirming your desire to see the zone change done for and lease properties. So just so you know, there is documentation from you requesting or looking for the zone change. So I just wanted to to go on record with that.
Excuse me, Mr. Bedetti, I did
Yes.
not request the zone change, and I don't believe that correspondence says that I requested it. Somebody may have asked me in conjunction with properties that I had under contract or under option, whether I thought it was something that I'd be interested in, which I may have confirmed. I don't have that correspondence in front of me, but at no time did I ever request the zone change for those properties.
I would just, your letter states you're confirming your desire to amend the zoning.
That's, somebody asked me whether they thought,
Okay.
if I thought it was a good idea based on what my plan for the property was.
I just want to
Confirm that it was okay with me, not that it was my decision or my request.
Now, just to understand the option on the lease property, does that mean that not necessarily going to happen with that project, the lease property, or it's maybe, or it has to, or?
No, it's a comprehensive assemblage. In other words, it's the Stonegate property, the Scheibel parcel, and the lease parcel, all merged into one with a comprehensive application for the entire development of 172 units. So the lease property, and again, if we were able to pull up the site plan, you would actually see that horrible house that's in such a state of disrepair would be slated to be demolished under this development plan, and that becomes the detention basin area for the entire development. So it is
Okay.
part of the development if we were successful in processing the entire application.
Okay, I just wanted to be clear that was going to be included in the project.
Yes, it is.
Okay. Now, you had mentioned 867,639.94. That was a number you said you have out so far in cash, I believe.
Let me just confirm the number I gave you, but I think that's correct. Yeah, 867,639.94.
And then you said you have 2.3 million invested.
Yeah, I have a mortgage on the property of about $1.5 million on top of the 867,000 in cash that I've spent so far.
Yeah, the 867, I'm not looking for it now. You have a breakdown in front of you of that?
Oh yeah, here's if you could see it, here's every sheet of every check that's been written for this development for, everything from application fees to engineering to architecture to surveying for the water main to you name it. That's what that's all about.
So it'd be fair to say you're prepared?
I'm partially prepared this evening.
Because-
I would have liked to have had some of the other things that have been asked of me this
Because-
evening. Had I known we were looking for those things, but yeah, financially, we've got it down to the penny. I can supply every record.
So you could tell me how much the Scheibel and lease property cost you then, or are going to cost you if you're in contract with it. You have everything to the penny, except that?
I don't have those contracts in front of me, but I could tell you in the minute I walk into my office tomorrow and I pull those documents, I'll tell you exactly what it is.
So this 2.3 million so far, that's not including the Scheibel and the lease
That
property?
does not include the purchase price for the Scheibel property or the lease property. That's
So
to
you have-
purchase the Stonegate property and process the application to this date.
Okay, so you have all those numbers except those two. Okay.
That's correct.
Another thing, you purchased, I know John said there was something about 600,000 gallons and you purchased, I think you said 42,000 gallons. And that was for the 195 apartments, correct? And not the
Yeah,
170?
I think it was 192, maybe. I don't have that. John, you might have that. But so now we're actually over reserved based on our current application. In other words, I've paid for a sewer allocation reservation for the 192 or 195. But if we were to get an approval for the 172, then we've spent money that we have no benefit for because there is no refund on the dollars.
Okay. Just one more question. Are you aware, was there any easements granted by the previous owner of Stonegate property to the town, all set for that water line that was going through there?
No, there were not.
So you're saying there was no easements by Tony Fine to the town at all then?
The reason that we closed on the property was because Tony Fine did not want to grant the easement to the town because it would have disrupted his underlying approval. So the only reason we bought the property, that we closed on it, was so that we could convey the easement to the municipality so you could run the sewer main through the property.
Yeah, there was
No other reason.
There was a water line design already to run through that property with the Tony Fine property then, right?
No, there would have been a proposed water line based on the underlying approval.
Okay.
There was no easement granted to the town because it just never got that far. And it would have been dramatically different in its configuration from what we ultimately engineered with your professionals and the DEC to develop the infrastructure to build that water main.
To fit your footprint.
To fit a footprint that we were working on collaboratively.
Okay. I have nothing else. Thank you. Thank you for answering them.
Okay, Stephen, thank you. Councilwoman Santiago, anything from you?
Yes, thank you, Mr. Supervisor. I too want to say that I came on board in January, and I spent a lot of time the past 2 years speaking with residents and so forth at different public hearings. And one of the things I heard a lot about was traffic. And I've spoken to people directly at Clarkview, just as Mr. Moreau had mentioned before. And one of their biggest complaints there has been traffic. As well as in other areas along 207. I did want to take the opportunity to read a correspondence from one of our residents, from Mr. Saeed Salim. He had addressed an email, attention New Windsor Town Board, regarding the PB 1817 Stonegate multifamily residential site plan. The New Windsor Town Board should not approve or entertain the Stonegate application in conjunction with an expansion of the project onto the adjacent lot, tax lots 26.2 and 31.22 to the east. 172 units, which are proposed on the 24.8 acres. The requested property is located off of Little Britain Road, also known and designated as Tax Map Section 4, Block 1, Lot 66.2, 26.2, and 31.22. The reason for the above request, the undersigned is requesting for all above members to review the zoning changes made for the above proposal. On or about January 13th, 2013, Tony Fine was informed by the town above location would be to multifamily zoning. On or about September 16, 2016, the senior citizen housing and workforce household was repealed. The property returned to its previous zone identification, which was PI, industrial. On or about February 7th, 2018, above listed property was zoning was changed to R5 multifamily use, indicating a zoning error had to be corrected. And in caps, he says, it was indicated above property zoning was changed due to correcting errors, but in fact, it was completely changed to a new zoning R5 to please the above property owners. The undersigned is requesting a full review of the February 7th, 2018 zoning change. The undersigned requests George Myers and the town board to take into consideration the water, traffic, and sewer issues the town of New Windsor is already facing. Can you imagine 172 plus apartments can affect our existing problem? Yours sincerely, Saeed Salim. Thank you.
All right, thank you. All right, listen, I think what I'm going to do.
Can I respond? Just real briefly.
Go ahead.
Yeah.
Go ahead.
Because Mr. Celine fails to mention that the comprehensive plan, which zoning needs to be in compliance with, called for these parcels to be residential. So we met with Mr. Salim. He's a very nice man. We've attempted to accommodate him, but his facts are just not correct here. And the other thing I wanted to relate to you, if the concern is traffic, commercial facility with truck traffic or other traffic on that road is the better zoning designation, because that's what planned industrial is. It had an 85% coverage there. And I think if I was here representing a warehouse or a manufacturing facility that was going to locate in the same location on these properties, I think the screaming would be whatever it is times about 5. So you have to take that into account. The traffic from here, we have an engineer who looked at it. The traffic from this project will be mitigated by including a turning lane, by eventually committing towards a traffic light. So this project, the traffic problem you have in New Windsor is you got the 5 corners and you're in an attractive location and you got people going from place to place that drive through those areas. I mean, it's just what it is. When I go from Home Depot to the health food store, I go through Parkview. I live in Walden. That's the traffic. This project will have people leaving, and it has provided a study that I wish you would take a look at and see what we propose to fix and address that problem. The same thing with water and sewer. People think this is rushed through. There are reports, there was studies, there was a process. The February meeting that he's talking about in 2017, it's not Nick who said it, it's your consultants, your planning board attorney, your engineering consultant, who reviewed and discussed that in a procedure, an open proceeding, and discuss why they were fixing it. Mr. Salim can disagree, but it doesn't mean he's right, unfortunately. And that's.
All right, listen, what we're going to do now is I'm going to open it up to the public. There's some people who are like calling in. So what I'm going to do is to mute you and Mr. Manoy. But however, take notes, because when these calls are done, you will be able to make some response. I just don't want to get into a back and forth. So when we take these calls, you will be muted, you and your client. But then when the calls are over, you will be unmuted and you will be able to make a response to whatever you think you need to respond to.
George, just really quick, one thing, George.
Yeah.
I'm sorry. I actually had a letter to read. I'm not going to read it because it's lengthy. It's from a resident on McNary, Marie Baruchian.
I have that letter here. Don't worry.
I employ anybody that's watching to go on their town website, and all the letters that we received are on there. So thank you.
Okay, but let's do that. So Patrick, we mute them. And how do we get these people up now?
We're gonna go through the public that's dialed in here. I'm gonna unmute you and call on you one at a time.
Okay.
You can speak or
Okay.
choose not to. First up is Carolyn Thorne.
Carolyn, you there?
Hi, can you hear me?
Yes, so I would appreciate if you would direct your comments to the board.
So you've received my letter and I put in there about the WETs, which is water, effluent, traffic, and zoning. All things that need to be looked at. I will say that I really resent Mr. Capella's statement about how the community is screaming. I also will say, as an RN who works in the hospital, to manipulate their need to COVID-19 is offensive. I'm not going to go any further than that. You have my letter, and I appreciate your time.
Okay, thank you. Your letter will be made part of the record. Okay, Patrick? Nestor? Hello, we're there? Mr. Nestor, Ms. Nestor?
There you go, Mr. Nestor.
Okay. We can hear you.
We can hear you.
I have no comment.
Okay. Next,
Marianne Romano.
Mr. Romano?
There's too much traffic in the area. It's a nightmare to travel anywhere. We don't need any more cars, any more apartments being built. Enough is enough.
Okay, thank you, Ms. Romano. Anyone else?
Ron Eaton.
Mr. Eaton?
Can you hear? Oh, just a minute. Let me try to. Can you hear me okay or?
I got you. Go ahead. I had you. You still with us?
Can you hear me?
Yes, I can.
Go ahead, Ron.
Okay. Firstly, there was a comment made about I've got time constraints in the leased properties and the options that I've got. The fact of the matter is you spend almost 2 years going back and forth trying to get a much broader and more expanded facility than what you're proposing now. And that used up your time. So that is not either the public's nor the town's problem. The second thing is totally disagree with whatever your traffic study shows because I go on that road every day. It's completely packed after 4 o'clock and it's completely packed at 6 in the morning. So I don't know when they did the study, and I don't know whether they did the study during an August month or some month when the schools were closed. But it is overrun, and we do have septic and or sewage and water problems, and it will change the entire area's outlook, as well as I don't know what impact that could have if we had ever had a main break into Lake Washington, which is a reservoir for I think it's the town or city of Newburgh. So I'm just against the project to be allowed to go to this size. Thank you.
All right, Ron, thank you. Anybody else, Patrick?
You have W. McCracken.
Mr. McCracken. Mr. McCracken.
I don't have any comment. Thank you.
Okay, thank you. Next,
Richard Horick.
Mr. Horick. Hello, Mr. Horick. Still on there?
Yeah, we'll go on. Last one, Samuel Bergson.
Mr. Bergson? Mr. Bergson? No?
No.
Anybody else?
Last one's 19085.
Last four numbers, phone number 19.
Nope, that's just the name he signed in with.
Okay.
Looks like he's gone.
Okay, can I add one thing if possible?
What's your name? Still there?
Ron Eaton again? Hello?
Yeah, Ron, you back again?
I am. I just had one quick thing, and that is if this board approves this, then you're going to have every single other project that has been contained by the moratorium demanding to have they're getting a waiver as well. And they'll do so on the basis, they'll say that once you've approved the other, you have set a precedent. And it will then make undermine your moratorium at this point. For this project to be delayed till I think it's October is when the moratorium runs out. I guess the question really goes back to the owners. Does that or does that not eliminate your timing with your leased options? Because otherwise, frankly, it shouldn't even be considered.
Okay, thank you, Ron.
Thank you. Sorry.
Did we find this other gentleman?
No.
No, it's gone?
That's everybody.
That's everybody? So I just need to comment on it, some letters that I received. They're all in favor of the board not approving this from John Thorne, and they all talk about the same thing, the traffic and the sewer and the changing of the neighborhood. So and we also have a letter here from Donald and Susan McCrossin with the same issue. We also have a letter from Marie Borjatin. I'm probably not pronouncing that right, but she's also very much against this multi-resident project back there. We also have another letter from Paula and Robert Camerata, also very much against this project because of the reasons that have been stated by the other people. Another letter from John and Joanne Ardenis, who are also against the project and talking about the moratorium and how it's going to create a lot of traffic and problems for the town. There's another letter from Christine O'Hara, and 4 other people who I don't see the names. It just indicates there's 4 other people on this. And they are also talking about the traffic, the water, and the sewer. There's a letter from Mr. Donald and R. and Mary M. Coyle. They are also very much against it. They also question the school, number of school children that are there. There's also a letter from Carolyn Thorne spoke, so we won't read her letter. She had her comments, but they are also very much against it. They also submitted a petition with 324 signatures on it. Stop Stonegate from building rental apartments in town of New Windsor. There's 96 New Windsor residents signed on there, 14 Newburgh residents, and 1 from Cornwall. So those are the comments and the letters that I just wanted to get in the record. So before I close the public hearing, I'm going to allow John and or Nick to speak again, and then I will speak, and that will be the end. So unmute. You guys.
Thank you. Yeah, I'll go and then I'll let Nick finish.
Okay.
I wanted to thank the board, and we will respond and give you written with the information and respond to the issues. But I just want to clarify a couple things. When you talk about, sometimes you can't win for losing. Comments have been made that this project will be an eyesore. It will increase crime. Those are in the letters that you have on your table. Those were submitted. Those were claims that were being made. In rebutting those claims, we provided information about the people who live in these projects. We invited you to drive through those projects. So that's, once again, factual information. That's not taking advantage of COVID or doing anything except letting you know the types of people who live in rental projects in your community. This is a good project for good human beings. I understand some people may not want it to be located there, but when we talk about sewer, water, and traffic, I'm not giving you an opinion. I'm citing the reports in the studies that have been made available, that have been made available to the public, that they could have had and commented on and provided actual information as to why the conclusions made on the report and the evidence analyzed is not correct. That's how you do the process, because whether you call it screaming or you call it commenting, it is people. Point I made, if you're going back and you're saying the zoning in 2016 that had this as planned industrial with an 85% development coverage was better for this neighborhood and this parcel than what's being proposed, I think that's disingenuous, and I think it's incorrect, and it's your job to balance the concerns of the property owner who's taken time, who's been there. And the last thing is, every application stands on its own merit based upon its facts. You have an excellent attorney, you'll talk to him, and if you determine that based upon these facts, this application could go forward, that is no precedence unless somebody comes back in with the exact same facts, which I doubt it. So that's my comment. And once again, thank you for your time. Nick, do you want to close with anything?
Yeah, I'd just like to thank you, John. I'd just like to add a couple of comments, and one of them actually has to do with COVID-19. I happen to be a trustee at the largest hospital network in New Jersey, employs 35,000 healthcare workers. I'm a trustee at that hospital network. It's a Robert Wood Johnson St. Barnabas network in conjunction with Rutgers University. So I'm very much involved in what goes on there and what's happened through COVID-19, and always encourage healthcare workers and first responders to live in our communities for that reason. I also happen to sit on a bank board, a multi-billion-dollar commercial bank in New Jersey. So in terms of community involvement, very much involved in banking, hospital board, and our real estate development. So we very much become a part of the fabric of the communities where we build and own and operate our facilities. I would lastly encourage every member of the board, as John has suggested, to tour our facilities, to drive through. I'd be happy to schedule a time to view model apartments and our clubhouse amenity facilities so you can see firsthand what it is that we're proposing and the lifestyle that we bring for your neighbors, your families, your sisters, your brothers, your parents, your children that live in these communities. So as an open invitation for anyone who would be interested in taking that time to see the facilities that are local. And I would also like to thank the board. It's been a lengthy hearing, probably much longer than everybody anticipated, lots of information. I would like to thank the board for the indulgence. And I would like to say to Supervisor particularly, I would encourage that there be some kind of a collaborative communication to try to resolve at some responsible solution where we would sit down and work hand in glove, so to speak, to try to figure out the best opportunity for the community, for the neighborhood, and for the development that we're proposing. So it's, you know, an open invitation that we would very much like to participate in if something like that can happen.
Okay, thank you, Mr. Manoy. Did you say someone else called in, Patrick?
She did, but she dropped off. There was an Amanda Livingston that she dropped off.
You dropped off?
Yeah,
Okay,
I don't see her.
she's not there? All right, so you know what, then, if she's not there, she's not there. Okay, so, John and Nick Manoy, that's closing that portion of it, mute them. Okay, now I'm gonna make a few comments and then I'm gonna close the public hearing. So I guess the first comment I wanna make is that, just the sewer treatment plant, just so you understand that it's a probably 7-year project. And it's not just repairs, it's an upgrade, it goes from 5 million to 8 million. There's a serious problem with sewer flow in this town. The I&I hopefully will do something, certainly not going to alleviate the issues that we have. So it's not a fix that's going to be 2021 or next year. We already have authorized 3 million, but we know it's going to be 45 million. Residential development, just as a point of interest for the town, usually is a push. In other words, you don't make anything. It's a push. We got a cops, we got every employees, we have to service them. Commercial, we do make some money for the taxpayers and able to keep the tax rate down. But residential, no, it's a push. Nothing happens. Talked about how you're helping run the town of New Windsor. I would need to say to you that we are more than capable of running the town of New Windsor. I know what to do, the board knows what to do, and we have the best interests of everybody at heart. I mean, we have to kind of consider our residents, but we also have to consider people doing business here, people who want to do business here. So it's very difficult for us to do that, but I would just strongly say to you that I'm the day-to-day guy and I'm very capable of doing this. I've done it for a long time and the board members have been involved a long time. And we will make the decision that's best for everybody. Nick talked about a meeting, but when you send a notice of claim that you're threatening to sue me personally and the town and Andrew Riggenbaum, I think that you've kind of taken it off the table. Now, if you don't understand that, talk to John. John will tell you. You don't threaten to sue somebody and think you're coming in to talk to them. That ain't going to happen. You've been submitting FOIL requests like it's been raining FOIL requests here from this law firm. Every day something comes in, and we have been responding. You have not been very well prepared tonight. You were guessing for some answers. You were going to get back to us on some things. This was your public hearing. You should have been prepared to answer these questions. And you appeared to me, in my opinion, you were lost. You were going to get back to us. You're going to tell us what it was all about. And in my opinion, again, it absolutely defies logic that you had nothing to do with the zoning change. Absolutely defies logic. And that you were only concerned about the New Windsor taxpayers. That also defies logic to me. So if I was you, I would be concerned about myself, as I'm sure you were. You were not concerned about the New Windsor taxpayers. You were concerned about your project, as you rightfully should be. But don't come and sell it to us as you had this great concern for the town of New Windsor. I mean, if you did, you wouldn't be threatening to sue us. You wouldn't be coming up with some things that just don't seem to make any sense, and you would have been better prepared. I hope the next time that we meet, and probably will you be taking some kind of deposition from everybody, that you are better prepared, because tonight you were not prepared. All right, you're going to guess, you're going to get back to us, you're not sure, and maybe Dave's right, maybe he's wrong, and we'll see what's what. So that being said,
We have the one resident came back on, Amanda.
it's too late. All right, let her on. We're not going to answer anything, but let her on. Amanda, you there?
I'm
Amanda?
here.
Okay, you want to make a quick comment? Go ahead.
I apologize. The opportunity to get back on. I apologize. I got disconnected earlier. I don't think I can pretty much add anything that's brand new to this conversation. But one of the things that I did want to just mention is, I know I can speak for myself and other residents from Philo Street that I don't think that our intention is to attack the integrity or the intention of what Nick is trying to develop. I've seen his developments and they are quite nice. However, I think that my concern and others' concerns really surround just maintaining what's left of the town that we all grew up in and giving it time to heal from all of the mass development that's been happening thus far over the last 15 years. So again, I know it's not brand new, but I think it was important just to highlight that most of us are not looking to attack your business or unfortunately cause you any more frustration or financial burden. But that was a different town supervisor, and that was also a different place where our board was when those decisions were being made. And I think that from here on out, you're going to start to see a lot more residents contributing to those conversations and hopefully the decisions that are made from here on out.
Yeah, I think it's a good idea. The residents need to get involved. They need to wake up, see what's going on, and open their mouth and speak up. Okay, Amanda, thanks for calling in. So that being said, I'm going to entertain a motion, Town Board, Town of Windsor, close the public hearing in the matter request for Diversified Properties LLC for administrative relief from local law 1/2020 temporary moratorium. Motion?
Move.
Somebody got a second there?
Second.
Roll call.
Councilman Regenbaum,
Yes.
Councilman Monroe,
Yes.
Councilman Bedetti,
Yes.
Councilwoman Santiago,
Sylvia, you muted?
No, yes, can you hear me?
Now we got you.
Supervisor Myers.
Yes, okay, Franny Roth, bye-bye. Bye-bye, she's waving to me. Okay, listen, the next item on this agenda is public comments on any agenda items, so I'll wait a couple of minutes to see if anybody pops up, and then we'll get going. See where we go. Oh. Everybody fell asleep, Patrick. Yeah. No one's here. Just those of us who have to be here. Okay. So that's the end of that. Okay. So there's no public comments, so we'll move on. Chair will entertain a motion, Town Board, Town of Windsor, approve the minutes of the regular Town Board meeting held May 6, 2020, as per a copy of those minutes posted on the Town Clerk's Bulletin Board and Town Hall, same having been distributed to each of the Town Board members. Motion?
Move. Move.
Second.
Roll call.
Councilman Regenbaum,
Yes.
Councilman Monroe,
Yes.
Councilman Bedetti,
Yes.
Councilwoman Santiago,
Yes.
Supervisor Myers.
Yes. Chair will entertain a motion, Town Board, Town of Windsor, authorize the supervisor to execute the attached change order number 2 within Callahan Excavating Company for the elimination of line number 2 to the existing water main offset, installation of 2 gate valves for water main installation purposes. Total net change resulting from the change order is a credit to the town in the amount of $13,020. Said change order shall be in a form acceptable to the town attorney with the approval of the town engineer. Motion?
Move.
Second.
Roll call.
Councilman Regenbaum,
Yes.
Councilman Monroe,
Yes.
Councilman Bedetti,
Yes.
Councilwoman Santiago,
Yes.
Supervisor Myers.
Yes, this is a pleasant surprise. Somebody's actually crediting us something. Very unusual. All right, receive and file. Hearing no objection, Town Board, Town of Windsor, receive and file with the town clerk the attached agreement for the expenditure of highway monies dated June 1st, 2020, between the Highway Superintendent, Town of Windsor, and the Town Board, Town of Windsor, in accordance with the Highway Law Section 284 for repair and improvement of the highways. This is $185,000 that gets moved back and forth between the general fund and our highway fund for Anthony Feo, our highway superintendent. It's getting the work done on our highways. Another receiving file. There were no objection. Town Board, Town of Windsor, receiving file the attached fully executed supplement agreement number 3 dated April 21st, 2019 between the Town of New Windsor and CPL, which is Clark Patterson Lee, for replacement of the Lake Road Bridge over the Metro North Railroad project, which is PIN number 875987. This is for $92,000. This project is getting very close to the end, right, Councilman Madedi?
Yes, it'll be done, I think, this third week of June.
Can't come soon enough. Hearing no objection, Town Board, Town of Windsor, receive and file with the town clerk the attached policy number OP22 New York 1133 88 75 54 54 dated March 25th, 2020 from Westcore Land Title Insurance Company for 6 roads commonly known as Betsy Ross Ridge, McKinley Court, Hamilton Way, Colonist Trail, John Paul Jones Lane, Panorama Drive, as well as 3 storm water detention basins located on Panorama Drive, Settlers Ridge Road, and McKinley Court. All roads and stormwater detention basins are located within the Mount Airy subdivision, commonly known as the Reserve. This actually happened on March 20th. March 20th, 2020. Another receiving file. Hearing no objection, Town Board, Town of Windsor, receiving file of the town clerk the attached spill prevention report dated April 2018, last revised 7 May 2020 for the Town of the Windsor Butter Hill Treatment Plant located at 181 Fortune Road in Windsor, New York. This had to do with a minor spill we had at the Butter Hill water plant. Receiving file, again, hearing no objection, Town Board, Town of Windsor, receiving file with the town clerk the attached amendment number 1 to agreement between the Town of New Windsor and New York State Department of Environmental Conservation dated July 26, 2019, extending the term of said agreement to March 31st, 2020 to allow New York State Department of Environmental Conservation to reimburse the Town of New Windsor for costs associated with extension number 5 of Water District 6. This is over on Steel Road that we had to supply some municipal water to folks whose wells went bad. Another receiving file. Hearing no objections, Town Board, Town of Windsor, receiving file with the town clerk the attached project closeout report from Quality Environmental Solutions and Technology Incorporated for the asbestos abatement monitoring and management services provided in connection with the asbestos abatement project at the Microstream building located at the Caesars Lane wastewater treatment plant. This had to do with removing some asbestos from that sewer treatment plant and getting us on the road to getting that plant expanded. Okay. Chair will entertain a motion. Town Board, Town of Windsor, authorize the town clerk to advertise pursuant to law calling for sealed bids for the sale of town-owned property located at 18 Road in Windsor, New York, identified in the Town of Windsor.
Video.
Section 9, Block 1, Lot 1042. Said property is commonly referred to as Masonic Lodge. Said advertisement will publish in the town's designated official newspaper on June 12th, 2020, with the request for proposal made to available prospective bidders beginning on June 15th. In recognition of Executive Order 20211, all initial proposals shall be received and opened on the 3rd day of August 2020 at 12 p.m. at the office of the Town Clerk, Town of New Windsor, 555 Union Avenue. The initial proposal opening will be live streamed over the internet on the town's Facebook page, subject to continuation of the aforementioned executive order. Following the opening of the initial proposals, beginning on August 3rd, 2020, continuing through and including August 17th, 2020, there will be a period of review and negotiations of the initial proposals. During the time, the town will review the initial proposal and may seek to negotiate the terms and conditions, including but not limited to prices offered. Final sealed proposal must be received no later than Monday, August 24th, 2020, 12 p.m., at which time they'll be opened in the office of the Town Clerk, Town of New Windsor, 555 Union Avenue, Windsor, New York. The final proposal opening will be live streamed on the town's Facebook page, subject to continuation of the aforementioned executive order. Town Board, Town of New Windsor reserves the right to reject any and all proposals and waive any informality or technicality in any proposal if deemed to be in the best interest of the town. Motion?
Move.
Second.
Roll call.
Councilman Regenbaum,
Yes.
Councilman Monroe,
Yes.
Councilman Bedetti,
Yes.
Councilwoman Santiago,
Yes.
Supervisor Myers.
Yes, the town is attempting to sell this building that for some reason we bought years ago out at the Masons Ridge complex. No one seems, the seniors don't want to go there, it's too far. So we're going to see what kind of price we can get for it, and hopefully we get a decent price. Chair will entertain a motion, Town Board, Town of Windsor, accept the proposal of an award, the contract for comprehensive master plan update to Lankin Tully Engineering and Surveying as the lowest responsible bidder in accordance with the general municipal law. Section 103 is recommended by the town attorney for the town of New Windsor in the attached correspondence dated May 28, 2020. Motion?
Move.
Second.
Roll call.
Councilman Regenbaum,
Yes.
Councilman Moreau,
Yes.
Councilman Bedetti,
Yes.
Councilwoman Santiago,
Yes.
Supervisor Myers.
Yes, this is ongoing, has married up with our moratorium. So we last did a master plan in 2000, I think it was 9. So you're required to do it every. So we are now going to do a new master plan, look at some of the things that we have in our master plan. And one of the things that I'm really concerned about is the zoning. So there'll be, Lankin Tully will lead it. There'll be a group of town employees and some residents involved in the committee. And hopefully we'll be able to straighten out a few things very publicly. The public will have an opportunity to speak, and we'll see where it goes. And their low bid was $40,000. That's what the cost is. Chair will entertain a motion, Town Board, Town of Windsor hereby find in accordance with the resolution attached thereto that Dr. John Fugo has failed to meet the burden of demonstrating by clear and convincing evidence, including dollars and cents proof, a need for administrative relief from the temporary moratorium. So the vote is he has failed. So if you think he's failed, it's a yes. If you think he has not failed, then it would be a no.
Second.
Roll call.
Councilman Regenbaum,
No.
Councilman Moreau,
No.
Councilman Bedetti,
Yes.
Councilwoman Santiago,
Yes.
Supervisor Myers.
Yes. Okay, so by a vote of 3 to 2, that has failed. Okay. Hearing no objection, Town Board, Town of Windsor shall receive and file the attached application of Empire Properties LLC for the administrative relief from Local Law 1, 2020, entitled "The Local Law to Establish a Temporary Moratorium on All Development Approvals in the Town of New Windsor." I'll speak to this in a minute. Chair will entertain a motion, Town Board, Town of Windsor hereby call a public hearing on the request of Empire Properties LLC for administrative relief from Local 1, 2020, temporary moratorium. Said public hearing will be held on July 1st, 2020 at 7 p.m. either in person to Town Hall 555 Union Avenue, New Windsor, New York, or by video conference and teleconference via Cisco WebEx on the same date and time with a link to log in and participate by computer and phone number and access code to call in and participate by telephone made available to the public by the town clerk in a timely manner pursuant to law. Motion?
Move.
Second.
Roll call.
Councilman Regenbaum,
Yes.
Councilman Moreau,
Yes.
Councilman Bedetti,
Yes.
Councilwoman Santiago,
Yes.
Supervisor Myers.
Yes, so in July, we'll have another public hearing just as we had tonight. And this time it'll be for Empire Properties. Lord, don't let it be so long. Chair will entertain a motion, Town Board, Town of Windsor, authorize the supervisor to execute 4 agreements between the Town of New Windsor and Hollenbeck Pest Control for monthly commercial pest control services at each of the following town-owned buildings: Town Hall, Moresco Center, Police Department, Community Center, Mount Airy Pavilion and Kitchen, Recreation Center, and the New Windsor Ambulance Corps. Motion?
Move.
Second.
Councilman Regenbaum,
Yes.
Councilman Moreau,
Yes.
Councilman Bedetti,
Yes.
Councilwoman Santiago,
Yes.
Supervisor Myers.
Yes, this is a new pest control vendor for us. The former pest control was from Walk Hill. This business is in town, so the owner owns the business. He lives in town. So I think we really need to try and, anytime we're doing business with anybody, we should try and do business with the people who pay taxes in this town. And I think the town board has discussed this and they're all in agreement that's the way we should go. Chair will entertain a motion, Town Board, Town of New Windsor, hereby approve the application of MFPJJ RT Enterprises doing business as Anthony's Pier 9, for outdoor amusements permit for an event to be held June 5th, 2020, with a rain date of June 19th, 2020, in the main parking lot of Anthony's Pier 9. The hours of such event shall be 9 p.m. to 11 p.m. Further, the town board pursuant to section 92(4) of the town code hereby authorize the town clerk to waive the fee for said application. Motion?
Second.
Roll call.
Councilman Regenbaum,
Yes. Yes.
Councilman Monroe,
Yes.
Councilman Bedetti,
Yes.
Councilwoman Santiago,
Yes.
Supervisor Myers.
Yes, Pier 9 is like all of our businesses in town have been struggling, and they're gonna run a movie out there, like a drive-in movie, and see what it make out. We have met with them, they met with the police department, and hopefully this will work out for them and they can kind of generate some revenue. And we just thought that the fee would be a little harsh on them, so we waived the fee. Hopefully they do okay. And we really are hoping that our businesses, which are all struggling, can get around to opening soon. The governor almost sounds like they're gonna have some movement early next week or late this week where these restaurants might even be able to do some outdoor dining, but they are in dire straits. Hearing no objection, Town Board, Town of New Windsor, receiving file the town clerk. Change order petition containing 324 signatures requesting stop Stonegate from building rental apartments in the town of New Windsor. That's the one I spoke about before. Hearing no objection, Town Board, Town of New Windsor, receiving file with the town clerk the attached notice of claim in the matter of diversified projects and DP Stonegate versus the town of New Windsor to Town Board. This is what I spoke about before. They have put us on notice that they're suing the town board, myself personally, and one of the council person personally. So I guess we can see what great neighbors they are. Even though it's actually Town Board, Town of New Windsor, receiving file with the town clerk, intermunicipal agreement between the town of New Windsor and the town of Montgomery dated April 16th, 2020 for cooperative information technology services. So what we do is the town, we have a well-run IT department, and other towns have contracted with us to their IT service, and they kind of have to sign a contract and pay us, and we kind of make a few dollars on this deal that we have with many of these towns. How many towns are we dealing with, you know?
About 15.
We deal with 15 towns. There's only 40 municipalities in all of Orange County, so 15 were probably over a third of them. No objection, Town Board, Town of New Windsor, receiving file letter of agreement dated May 13th, 2020 between the town of New Windsor and Orange County IDA, which extends the lease term for one additional 2-year period for property commonly known as 334 Avenue of the Americas, building 2416 in Windsor, New York. The term of the lease is modified to commence June 1st, 2020, expire May 31st, 2022. IDA is already in that building. They had an option, and they exercised that option. They came a little late with it, but they exercised the option, so we'll continue to rent that building to them. No objection, Town Board, Town of New Windsor, receiving file with the town clerk the attached New York Forward COVID-19 reopening safety plan. The state of New York has required every business and every entity to file a safety plan when they reopen, and this is on file with the town. This is the town's. We have been opening, and we have taken a lot of precautions. Everybody who comes in has to wear a mask. There's 6-foot social distancing, and we have lots of hand sanitizer around, and we are still recommending, if you don't have to come, you can deal with us either telephonically or through one of the IT departments. And we have been getting some traffic, and a lot of it's been in the building department because the builders have been in dire straits too. So people are beginning to come around and be able to do something. Thank God. Hearing no objection, Town Board, Town of New Windsor, receiving file with the town clerk the attached commercial insurance policies for commercial property coverage, commercial general liability coverage, commercial crime coverage, and commercial inland marine coverage, each of which effective December 24th, 2019, to December 24th, 2020. This is for all our insurances for the towns, and we have to do this receive and file. No objection, the town board, town of Windsor, receive and file with the town clerk the attached GASB 75 actuarial evaluation for the year ending December 31st, 2019, as prepared by Summit Actuary Services, LLC. What this is that it's how much we are in debt for some of the things that we provide, and this has to do with health benefits for all our employees and retired people, and recently it became law that you had to list that as a liability. So that's what this is about. Hearing no objection, town board, town of Windsor, we shall receive and file with the town clerk the attached monthly reports for the following departments, May 2020. These are all for May 2020. Justice Calderon, Justice Myers, Police Department, Building Department, Recreation Department, Tax Receiver, Utility Report, Town Clerk, and the Windsor Volunteer Ambulance Corps. Okay, so we are now almost at the finish line. It's only 9:15. So what could be better? So at this point, I'm going to open it up for a public forum, but before I get to any public, if they're still awake, I'd ask any of the board members, if they're still awake, if they have anything that they'd like to speak to. Okay, I'm taking that as a no. Patrick? No one, see, they all fell asleep. I don't mean the board members, I mean the residents. They've seen enough. Is there such a thing as combat pay? Somebody ask Finnegan tomorrow. Okay. So
Thanks,
Chair,
guys.
what do you call?
I said, thanks, guys, for a good meeting.
Okay. Okay, thank you. I'm just happy I'm still awake. Motion, town board, town of Windsor, adjourn the town board meeting at 9:16 p.m. Motion?
Moved.
I have it at 9:19, but I'll second it.
Okay, 9:19. Motion.
Move.
Second.
Roll call.
Yes.
Councilman Monroe,
Yes.
Councilman Madeti,
Yes.
Councilwoman Santiago,
Just want to say first that Amanda just wrote and said she's still with us, but I vote yes. Thank you.
You want to vote
Supervisor
no?
Myers.
You can vote no if you want to. Me?
I'll stay on all
Yes.
by myself.
You can stay. All right, Patrick, we done?
Thank you, Patrick.